Hi, I'm Chris Chimicles, President of Angeion Group, and welcome to our Leading Litigators series. Our series brings together some of the best and brightest class action practitioners from both the plaintiffs and defense bars, and most importantly, the attorneys that made case law. Enjoy our series.
Hi, I'm Steve Weisbrot. Welcome to the latest installment of Angeion's Leading Litigator video series. I predict that this will be one of our most viewed and perhaps most controversial guests that we've had. It's our pleasure to have today Ted Frank, Senior Attorney at the Competitive Enterprise Institute. Thank you for being here, Ted.
Thanks for having me, and thanks for the use of your makeup artist.
Full service shop. So Ted, to be frank, no pun intended, I feel like the majority of our viewers are very familiar with you and your sort of body of work and what it is you do. But the way I want to start off the interview is by asking you, if you were at a cocktail party tonight and you met someone who's not an attorney, not in any way, shape, or form part of the class action world, and they said, what do you do for a living? How would you respond to that question?
We work to make the class action system more effective by making sure that the attorneys who represent consumers and shareholders are working for the benefit of consumers and shareholders.
Okay. And if their follow-up was, well, why don't you just work directly for those consumers and shareholders?
Well, we do represent consumers and shareholders, and also nobody else does what we do, and I think we add an important part to the class action system. There are lots of people who make a lot more money than I do representing the plaintiff side of things, and we're a nonprofit that tries to make the system work more effectively.
So clearly what you're talking about in making the system work more effectively is objecting on behalf of certain class members to many different things in a settlement, right? Although there are some that repeatedly come up, and we can get into that. You recently tweeted, you wish you could see, and I'm putting words in your mouth, but something like a checklist from the plaintiff side on how to objection-proof a settlement. If you were drafting that document, this is how you objection-proof a settlement according to Ted Frank, what would that look like?
I think it's pretty straightforward. You set up a common fund that reflects the litigation value of the case, and then the attorney's share of that is proportional to what the class gets. And it's up to the attorneys to figure out how to get that money to the class, working in conjunction with the settlement administrator.
So only common fund settlements?
Well, there are times when injunctive relief is appropriate, but in general, we find that injunctive relief is generally there to create the illusion of relief without any actual benefit to the underlying class members.
Now, certainly there are going to be attorneys and laymen who take issue with that statement, right? I was recently at a conference and I heard someone talking about, and I don't know if you were involved in this case or not, I don't know if there was an objection to the settlement or not, but I thought it was a fairly good example, and I'm going to guess that you're going to disagree with me, but a case involving sunflower seeds and salt content, where the company allegedly, and I've never read any of the documents, I just heard someone speaking about it, company only provided the salt content for the actual sunflower seed within its shell, whereas normal people who ate these sunflower seeds were, sucking on the shell, biting them, and the injunctive relief that was brought, I think, was to have full disclosure over the real salt content so people didn't get sick or ingest more salt than they should have under their own medical plan. Is that, in your opinion, illusory, or is that real relief?
Well, it sounds like they were mislabeling the sodium content on the FDA required label. And that's essentially the same lawsuit as the one involving Seinfeld's non-fat yogurt shop, where they were selling full-fat yogurt and calling it non-fat. And everybody came in and said, okay, now we're getting non-fat yogurt. And the question is are they settling a B2 class action where they're seeking injunctive relief, or are they purporting to waive everybody's claim to damages under B3? And if it's a B2 injunction with no waiver of the B3 claims, that's an appropriate use of the class action system. If, on the other hand, what's happening is that they're waiving the consumer claims to get the injunctive relief, well, the consumers who are waiving the claims aren't getting any more relief than the consumers who are opting out, or the consumers who are coming to the product anew and don't have any cause of action. And those consumers, if the attorneys were fulfilling their fiduciary duty, the class should be advised to opt out of the B3 claims, take the benefit of the injunctive relief, and not waive their damages claims. So we have a problem when people are waiving their damages claims and getting nothing more than anybody who doesn't have a damages claim gets.
Could you identify for me 3 sort of B2 or B3 hybrids that you think were done properly and that are meritorious and worthy class actions?
Yes.
Would you?
Oh, well, do you mean that the class action was appropriate, or that the settlement was appropriate, or?
I'm gonna couch it in terms of settlement, because typically that's where you get involved. That's also where I get involved. So let's talk about it at 3 settlements where it was a B2, B3 hybrid that you felt were done properly in your legal opinion.
I mean, we come across cases all the time. I mean, we're essentially at this point reviewing just about every class action settlement that gets sent to an attorney general under the Class Action Fairness Act. We have an outstanding FOIA request, and we get those documents within a month of when the AGs get them. And we go through these things all the time and find, okay, this is a straightforward securities class action under B3, and the attorney fee request is reasonable for the degree of risk and the degree of litigation they went under, and the class is getting money, and there doesn't seem to be an inappropriate cypre provision, and we move on, and we don't think about it. And there are a lot of those, and we see consumer class actions where there is a real common fund created, and the attorney fee request is proportional to what the class is getting, and the class is not surrendering rights beyond what the litigation value of the case is, and there's injunctive relief on top of it to stop the abuse of practice. And we say, oh, darn, we were hoping to get involved in that one because it's a really sexy case that would have gotten us a lot of publicity, but there's nothing wrong with the settlement. And we're not going to object, to make up an objection. There are too many bad class action settlements out there.
So if you sort of had a matrix for your case selection, clearly you just said that there is certain cases that are sexy, and you know that there's press appeal, right? Or I don't even know if that's the right term, but you understand what I'm saying. And then what else is on that matrix? What are the key issues? Is it attorney's fees? Is it the B2/B3 issue that you previously identified? What's going to get someone flagged in Ted Franklin?
Well, I mean, we have a long list of issues that, boy, we're looking for a case where that happens. So cases with A4 problems where they're glomming together people with different sorts of claims, but the same sort of relief, and it makes a material difference. We're looking for cases where, and there are cases like this out there, where every single class representative objects, and then it's crammed down, even though there is no class representative that approves of the settlement. We haven't had a chance to litigate those, but we're looking out for them. We're looking out for abusive cypre. We're looking out for excessive attorney's fees. We're looking out for illusory settlements where they issue the press release saying it's a $50 million settlement, but in fact the class is getting $300,000 and the attorneys are getting much more than that. So we're looking for cases that can create precedent, because again, we want to maximize our impact with the little resources we have. So is there a clean appellate issue if the district court judge rules against us, or is this a complex factual question where it's going to end up being an abuse of discretion, and even if we're right, we have no chance on appeal? What are we accomplishing? A case that is more likely to get attention also furthers what we're doing, because it makes more people pay attention to what happens, and it's just a holistic thing. Sometimes it's as simple as, well, boy, that's in a really difficult city to get to, and it would cost us a lot of money to hire local counsel, and nobody particularly wants to visit that city. and we're really busy that month, and we won't object. We're always playing triage. Here are the 7 cases we could object to, and that we have clients who have come to us, or that we know class members who are willing to object, and which 4 or 5 do we have time for, given what other appeals come up and create workflow, and then we have to leave slack because there are always weird emergencies.
Sure. How many attorneys are on staff now?
So we just hired our 6th attorney, including me. Some of them are part-time, but they're all experienced people.
I want to talk a little bit about just the idea of consumer rights.
Sure.
It's my understanding, and you can correct me if I'm wrong, that you are at least not opposed to arbitration in consumer contracts.
I think that's correct. I think consumers have freedom of choice and freedom of contract, and it's rational for consumers to say, I'd rather have a contract that has an arbitration clause than one without.
I'm not going to get into whether it's normally a meaningful choice. I think we're going to have to agree to disagree on that.
Well, Judge Easterbrook's written on this. There's a very good 7th Circuit opinion on the idea of whether it's something with a clause like this is a contract of adhesion.
Sure.
You can't negotiate with Toyota to get a 5-wheel car, and it's not that they're forcing 4 wheels on you. It's a contract of adhesion. And it's what the market demands, and you can take it or leave it.
Is it fair to say that you also support the weakening, and I'll leave it at that, the weakening of the CFPB's enforcement powers?
Well, the CFPB is unconstitutional, so to the extent that an unconstitutional agency shouldn't exist, that's correct.
And clearly your criticisms of the class device are well known, right? So,
well, I mean, the class device is a potentially very useful thing. I've very happily been a class representative where I thought it was appropriate.
We're going to talk about that, I promise you.
But on the other hand, it's also a tool of abuse, as in merger strike suits or a handful of other cases where we've come into, and it's very clearly attorneys glomming on without actually providing any relief to consumers, but trying to extract a fee for themselves.
Okay, but I guess my question is, right, if you're more or less pro-arbitration clause, you believe the CFPB is unconstitutional, you have your issues with class action devices, how are consumers supposed to enforce their rights? What other avenues are there? Am I missing something? I just don't know how, under the rubric we just discussed, consumers can purposefully enforce their rights in any meaningful fashion.
Well, if you've read what I've actually written about arbitration, I say a prerequisite before you say the arbitration clause is appropriate is that the arbitration provides an avenue for meaningful relief for consumers. And in reality, it does. And consumers are often ex ante much better off with the arbitration, both in terms of lower expected litigation costs, savings which can then be passed on to the consumer. Second, most litigation between consumers and vendors, especially in the credit card arena, are the consumers the defendant, and consumers have much more rights as defendants in arbitration than they do in the court system, where in a court system a default judgment, which is what happens well over 90% of the time when a credit card company comes after you, is just simply a rubber stamp by a judge without any scrutiny behind the allegations of the complaint, whereas the arbitration rules, the arbitrator actually acts on behalf of the consumer to make sure that there are no unfair claims, and very frequently reduces what's demanded by the credit card company. So consumers are often much better off with arbitration than with the current litigation system, and it's a reasonable choice for a consumer to make in many instances.
Are the corporations better off, or the credit card companies better off?
I think it's a win-win. It's further out on the Pareto curve because we're losing the deadweight loss that a lot of litigation creates.
Okay. Well, I'm not Paul Bland, and I'm not going to sit here and vociferously disagree with you, but I think that there are obviously very strong voices that talk to the inherent power imbalance the lack of sort of res judicata that arbitration would give, the sort of secrecy that's associated with arbitration. But that's all fine. I still, and maybe I didn't hear the exact answer. In a perfect world, is your answer the way for that consumers should enforce their rights as arbitration when available and otherwise X?
I mean, consumers have a variety of means of enforcing change and making things happen. And we just saw this with United Airlines, where United Airlines probably actually acted quite legally when they demanded David Dow get off of a plane and then called the police when he refused. But at the same time, consumer outrage was very, very strong. United saw a risk to its market position and changed its policies. Consumers, especially in the 21st century, especially in the internet age, have more power than ever before, and the market responds, so long as we're not talking about a monopolist like a public school or something like that. Consumers have the choice and can generally get corporations to do what they want.
So earlier you alluded to the fact that you are currently a class representative in the Telephone Consumer Protection Act suit. I believe your attorney, I know your attorney is Jay Edelson. I want to talk a little bit about that. I want to talk about why someone who is known for objecting to certain settlements has decided to, A, become a class rep. I want to talk a little bit about why Jay Edelson was your selection of attorney. Clearly you are familiar with the grand majority of class action plaintiffs' attorneys, and even especially within the TCPA world. I know that you've had some criticism of attorneys in that world. And then I want to ask you the hard question. And, you know, I think that some people are of the opinion that you're only acting as a class representative to add sort of credence to some of your objections. You can say, well, Judge, I'm not I don't think class actions are bad. I'm a class representative. How could you say that I say that when plaintiffs' attorneys are painting you with that brush in those situations? So in any order that you'd like, I would love to sort of understand the whole Ted Frank as class representative thing.
Well, these guys called my cell phone with an auto dialer, and that's illegal, and it really annoyed me. And then I offered to settle the case with them, and they laughed at me. So like, okay, that's what the class action system's for. That's what the TCPA is for. The TCPA is misused in a lot of ways, but this is right exactly what the TCPA was intended for and what Congress wanted to have stopped. And I'm very happy to. When somebody has a business model that's functionally illegal, I'm very happy to vindicate those rights. And I wish I could do it more often, because I get far more TCPA violations on my cell phone than defendants I can track down. Why Jay? Jay was willing to do it. And I think, Jay is the one class action attorney where we see one of his settlements and we have a question about the claims rate and whether the attorney's fees are proportional to the claims rate. And I mean, every other attorney we've just stopped asking because we don't get an answer. And
so Jay gets on the phone and he walks through it.
And Jay will get to the phone, he'll walk through it, and it's not always perfect, but usually it's something that in our system of triage, where we have limited resources, we're not going to go to Jay and say you're overbilling the class by $200,000 when there are multi-million-dollar violations going on, when there are real appellate issues that are much stronger.
And what about the criticism that you're posturing? I know you have the right to bring the lawsuit, there's no question about it. It just seems antithetical to a lot of things that you've done, said,
I
etc.
don't think it's remotely unethical. I've always been a consumer attorney. I grew up admiring Marvin Zindler, and with Marvin Zindler being Autograph being one of my prized possessions. I read Consumer Reports cover to cover. Everything I argue for is on behalf of consumers, even when it's tort reform, because a lot of litigation adversely affects consumers. And I've gone on national TV and say, I support class actions, and it doesn't matter. I still get people lying about me in pleadings saying Ted Frank wants to get rid of all class actions. And, I can complain that that's not true, and I've said otherwise, but here I'm putting my money where my mouth is. Look, I don't want to get rid of all class actions. I think class actions are an appropriate means of aggregating claims in many instances, and this is one of them. And now go ahead and say that so I can make my Rule 11 motion, because I'm really tired of you people lying about me.
What happens in the event that the settlement in this case that's offered does not comport with sort of your common fund only requirements, and how much influence under the relevant canons of professional ethics do you get to exert? How do those conversations happen? And please, I'm not asking for anything privileged, obviously, but I'm just curious what the dynamic's like, because listen, you're not the average plaintiff here, right?
And I'm pretty sure Jay understands that, and I'm pretty sure Jay doesn't
want
the...
Of course he does.
Jay is very excited to have me as a client, judging by the press releases, and I don't think he wants that sort of falling out. Maybe I'm naive, and I've been naive before. One of the things that's always impressed me about this is that every time I think I'm far too cynical about the system, somebody does something and says, wow, I was really naive. It's much worse than I thought. But at the moment, I believe I don't have any reason to think that Jay is going to try to embarrass me with a bad settlement. No. And then try to force it down the court. But like I said, we've been looking for the sort of case where the class representative objects to the settlement and the court approves it anyway. Right. So if Jay wants to do that to me, well, that's great. I've been looking for
I'm not
that case,
suggesting that that's the case at all. Let me be clear. I think Jay is an ethical and intelligent attorney, and I think that wasn't my suggestion. I was just trying to understand, because, like I said, it's an atypical situation, to say the least, right?
It's an atypical situation. It's an atypical TCPA case. Most of these cases are brought against deep pockets, and this is one where it's not somebody who's arguably in technical violation of some interpretation of the TCPA, and can we hold them up for $1 billion and get 1% of that? This is somebody whose business model is TCPA violation, so I'd be curious to see how that shakes out. But we'll cross that bridge when we get to it.
Absolutely. So one of the things you said, I think that often gets lost for me, is when an objector is objecting to a settlement, I often get the feeling that the idea that this is indeed a settlement where there needs to be compromises on both sides, and it's not an enforcement action by the FTC or something like that, gets lost. You said they're not a deep pocket, they don't have everything, and I think that a lot of times the requirements of the litigation come out as a negotiated settlement.
Oh, absolutely.
And I feel like a lot of objectors hold settlements to the standard of an enforcement proceeding by a government agency, and that's something that's concerning to me personally, given what I do. And I was just curious your opinion on that.
Oh, absolutely. And we do have consumers who come to us and they say, look at this settlement, they're hardly getting anything, it should be much bigger. And we're like, well, what's your evidence that it should be much bigger? What's your evidence that these guys are in cahoots with the defendant? Because no judge is going to find that. There was probably a very professional mediator there making sure they were negotiating at arm's length. And I don't think it's happened, maybe once or twice, that we've come in and said these guys are engaged in a reverse auction or otherwise trying to screw over the class by absolving the defendant and not getting as much as they should. And, I've had other people say, that settlement you objected to, the real problem there was that they incompetently litigated. And I shrug, that's not what we do.
Right.
We're there on the allocational issues, on the issues of settlement structure, on the issues of creating the illusion of relief and then demanding fees for it without actually getting the relief. We have a settlement that we just briefed to the Ninth Circuit, supported by 13 attorneys general, state attorneys general. And they say this is a $38 million settlement. And in reality, what the class is getting is coupons that are valued at $26 million, but they expire in a year and they're only for flower delivery and they're not good on Christmas or Mother's Day or Valentine's Day. And nobody's going to use these coupons. And they're worthless. And so it's really a $12 million settlement where all the money is going to the attorneys except for $3 million of cypre that's coincidentally going to the attorney's alma mater. And we're not saying the defendant has to put $38 million of cash on the table. Fine. If they think it's a $12.5, $13 million settlement, settle it for $13 million, but then make sure the class gets a proportional share of that, especially in a case like this one where the defendant was probably doing something wrong.
Right. Well, I'm not familiar with that case, but the way you describe it, it certainly doesn't sound like it's the best settlement I've ever heard. But let me ask you this, and I kind of asked it to you a different way right when we started. And how do you respond to sort of the allegation, accusation, whatever you want to call it, that not just Ted Frank, but that people who frequently object to settlements are heckling from the cheap seats? They're not bringing the suits themselves. They're not defending the suits. They're coming in after the fact, after people have litigated for years, in some cases more effectively, in some cases less effectively, but they were boots on the ground, they were doing the trial work, they were taking the depositions, and here someone comes in after the fact and says, this is why it's wrong.
And courts, I think, pretty uniformly reject those objections. We don't bring them. Those are not the types of objections we bring, and I think that's a valid criticism of a lot of objectors, or at least a lot of objections, that you can't come in there and say, this isn't enough. Well, why do you say that? And are you going to put up, it's a $20 million settlement. Are you going to put up $20 million of your own and take over the case and litigate it? Right. And I think somebody should do that in one of these reverse auction cases. If you're really saying it's a reverse auction and they're settling it too cheap, post a bond that says, we guarantee the class will get at least as much as this settlement, but we want to take it over and litigate it and get the class more. And that doesn't happen, so I tend to think that a lot of the criticism on the heckling side is appropriate. As you were saying, that there are objectors out there that. And I mean, we have one of these in one of our current cases. It was a pretty small settlement, and the relief is kind of worthless. And we understand that, but we think, okay, you brought a pretty meritless case that lots of people had lost before, and now you're getting a settlement, but all the relief is going to you, the attorneys, and that's not appropriate. And some other nonprofit has come in and said, this is outrageous. They're doing lots of wrong, and they should get a much bigger settlement. And we haven't seen what the response to that objection is going to be, but it's probably going to be, well, you brought this case and you lost it, and here we are, we're getting something. Right. Why are you heckling us?
What's the most misunderstood thing about you and what you do?
Well, I don't know if it's misunderstood or just disingenuous. I think a lot of the people who criticize me don't try to understand what we do. I hear a lot, I'm trying to get rid of all class actions. That's just simply not true. I hear a lot, I don't want attorneys to get any money at all, and that's also simply not true. I couldn't tell you what the most misunderstood thing is.
No, that's fair.
I'm not the shadow and can't see into the hearts of men.
What's your opinion on HR 985?
I think it's poorly drafted and it needs a lot of work. I think it has no chance in its current form before the Senate, so I haven't thought very hard about it. at some point I need to make an appointment with people who have sort of the authority on the drafting language and say, you put in this clause to try to support the kinds of work that CCAF is doing, but your language is actually going to make things worse and is inconsistent with existing language in the Class Action Fairness Act.
I'm not asking you to quote the bill, but I mean, what are the things you're talking about that you believe are inconsistent with the mission of the Center for Class Action Fairness?
Oh, well, there's a provision in there to try to tie attorneys' fees to class recovery, and it's, I think, intended to be a codification of what the Seventh Circuit has said and what some other courts have said, not always consistently, about attorneys' fees and compromised consumer class action settlements. And one, there are some loopholes in the current language that I'd rather not discuss there and let somebody figure out if it unfortunately passes the way.
Are you sure you don't want to discuss that?
And I think the provision is meant to codify Judge Posner's opinion in Pearson 772 F. 3rd 778, and several other appellate decisions similar to that, saying that attorneys' fees should be proportional and related to the actual class relief rather than some hypothetical speculative relief. The language in the bill doesn't quite get to that point, and I think has some loopholes that somebody will eventually discover and exploit. And I think more problematically is that there's already language in the Class Action and Fairness Act in Section 1712 relating to coupon settlements, and if you make the cash settlement language more harsh than the coupon settlement language, you're actually creating a perverse incentive to create coupon settlements that are worse than the cash settlements.
Interesting. So the Rule 23 subcommittee recently approved some amended rules. I want to ask you about two of them. I mean, I think you and I actually both gave public comment to the subcommittee on the same day. And I spoke predictably about notice, and you spoke predictably primarily about the objectors portion. And I would just like your opinion on both of those amendments while we're here today. I mean, how do you feel about it?
I don't have an opinion on the notice section. A lot of other people have very strong opinions.
Sure.
My view is that if you tie the attorney's fees to what the class actually recovers, the notice provisions will take care of themselves, because then the attorneys have the incentive to make sure that the notice works. In shareholder cases, we see a systematic problem of shareholders getting late notice, and that the notice provision is designed to give them late notice. And
well, I'm just going to take umbrage with the fact that you said it's designed to give them late notice. I mean, I have a lot of competitors in this business, and a lot of people were always trying to win the work. I would never, on my darkest day, ever accuse another notice administrator of designing something to fail on the notice side. I don't believe that, and I don't think such is the case.
Well, we have a case in the Fifth Circuit where the judge actually ordered a specific notice provision, and the settlement administrator submitted a declaration that frankly admitted that they were in contempt of court and didn't do the notice the way the judge wanted. And the judge signed off on the settlement and on the notice and said this was the best practicable notice, even though right there was the evidence in black and white that the notice wasn't what had been ordered. And
again, I don't know the case, haven't read the case law. I don't know if that's negligence. Maybe they screwed up. It's the use of the word designed.
It's not negligence, because it's 100% of shareholder cases, and I always get my notice late. I got my notice late in the Sears case. I got my notice late in the Citibank case, and it's gotten to the point where now we're very systematically and not. Systematically is the wrong word, but we're trying to track these cases before the notice goes out and find out about the preliminary approvals before the notice goes out, because we know we can't rely on the notice. And in fact, in our Walgreens victory, our client never got the notice in a timely fashion. But we knew that he was a shareholder, and we knew he was affected by the settlement, and we were able to object in the absence of notice. And then the notice came in well after he filed his objection. And it was a notice plan that was designed to get him his notice well after the objection deadline. And we're looking for opportunities to litigate that, and we can find out through discovery whether it's designed or whether it's just a massive coincidence that it happens every single time. But other than that, I think
no other strong opinions on the notice stuff.
I don't have strong opinions on the notice stuff. I imagine. I think once you align the incentives of the parties to maximize class recovery, because the attorneys are getting paid only when the class does, and we have absolutely seen this in case after case after case. For example, we just filed an objection. In one of the food court cases, and our objection was our client filed a notice and she got a claim form back saying that she was claim number 2601, and your attorney's fees request is based on the idea that there are going to be 500,000 claims, and we're pretty confident that there are not going to be 500,000 claims, and here's all the things you didn't do in the ways of notice to sort of that had the effect of reducing the number of claims that were filed. And immediately after our objection, suddenly all these things that we said in our objection should have been done started getting done. I mean,
again, not familiar with that case. I have no idea
sure,
what you suggested.
But in the Duracell case,
no. But I was going to bring it back to a point. I don't mean to interrupt you.
No, go ahead.
But I think I don't know that case. I don't know what the budget was. But what I was sort of alluding to earlier when I said a lot of times people treat a settlement, especially on the notice side, as if it were an enforcement action. It wasn't a negotiated compromise, and that you can always criticize a notice plan for not doing every single thing available, but there isn't an unlimited pot of gold. And I guess that's what I was trying to.
You're right. You don't advertise on the Super Bowl.
Right.
You don't spend $30 million on notice to distribute $1 million.
Exactly. That was.
And we're always for reasonable things.
So Ted, I've got to tell you, this has been very interesting to me. It was very exciting to have you as a guest. I've been looking forward to having you here.
Well, thank you.